Hi, everyone. Thank you so much for joining us today. I'm going to give it like another minute for people to filter in, and then we'll go ahead and get started. All right, I think we can go ahead and get started. Hi, everyone. My name is Shloka Krishnan. I'm the Development and Communications Manager at the AIDS Legal Referral Panel. Thank you all for taking time this Halloween to join us today. I did not change the date on this first slide. It should say October 31st. For this presentation on asylum law from Rachel Kafele and Becca Holt of Oasis Legal Services. Really glad to have all of you here today and to have them presenting with us. So just a quick agenda for today. I'm going to provide a little overview of ALRP. I think we have some people in the audience who are new to us, which is great. And then we'll move into the training, and we'll have time for Q&A at the end. When you leave the Zoom, you'll be redirected to an evaluation form. Please make sure to submit that evaluation form because that's what will prompt us to send out a certificate of attendance for CLE credit. That is a manual process, so it won't happen immediately, but we will definitely get those out to you in the next few days. Some quick housekeeping. The training is being recorded. Participants are all muted, but you can enter questions into the Q&A function, and we will address them throughout the presentation. If for some reason you can't access the Q&A, like you're joining by phone or something, you can also raise your hand and we will be able to unmute you if you need to ask a question that way. As I mentioned, please make sure to complete the evaluation form. If for some reason the link doesn't work right when you exit the Zoom, you'll also get the link in an email tomorrow. And everyone should have received the presentation materials, but we'll send those out as well when we're following up with you afterwards. So just a quick introduction to ALRP. ALRP was founded in 1983, and we've been around for over 40 years. Our mission is to advance and protect the rights, dignity, and health of people living with HIV/AIDS in the Bay Area. When ALRP was founded, really it was a group of volunteer lawyers who got together to draft emergency wills for people who were dying very quickly. Since that time, the landscape has obviously changed significantly, but there are still real challenges associated with managing a chronic health condition that can be exacerbated by stress, that can be exacerbated by immigration status, housing instability, any number of legal issues that destabilize a person's life. So what we're doing these days is really working to connect people living with HIV to the full array of civil legal services to help make sure they have the stability that they need in their lives to maintain their health and thrive. We do that in a couple of ways. So we have a team of about 11 in-house staff attorneys. We have a really robust in-house eviction defense program, and we do a lot of housing work in-house. In addition to what we have capacity for in-house, we also have a panel of several hundred volunteer attorneys. And that is how and referrals to those attorneys is how a lot of our clients receive the sort of comprehensive services that they need. So our panel attorneys' expertise really ranges from, family law to medical malpractice to bankruptcy, to all sorts of things. And so they play a really critical role in providing our clients with the low-cost legal counseling and representation that can make an enormous difference in their lives. Some quick stats. Since 1983, ALRP has handled almost 100,000 legal matters for people living with HIV. These days, about 80% of our clients are living on an income of $30,000 or less annually. So again, the sort of free and low-cost legal services that we provide and that our panel attorneys provide are really critical. So just a quick pitch, right? Our goal in offering this training series is twofold. So first, we really are just, hoping to increase the capacity of attorneys who are serving our community. But we are also hoping to recruit new talent to join our panel and to help meet our clients' legal needs. So if you are not yet on the panel, we hope you will consider joining. I think many of our panel attorneys will attest that it's a meaningful and positive experience for them and a way to give back to the community. It's also as small or large a commitment as you want it to be. So in general, we ask that panel attorneys accept 2 referrals a year. That can be, as limited a commitment as providing to clients with a consultation that sort of like explains the legal avenues available to them. But it can also always be a much deeper commitment than that. And you're always welcome to, dive in and provide as extensive representation and support as you are able to our clients. So how the process works is we, conduct a thorough intake with a client who comes to us, identify their legal issue or issues, do a bit of matchmaking, figure out whether it's something best suited to handle in-house or through referral to one of our panel attorneys. If it's best suited to a referral, we'll like sort of look in our database, do a bit of matchmaking, find someone with the relevant practice areas, maybe in the right county, maybe with relevant language skills for people who are non-native English speakers. And then we'll reach out to you and ask if you're willing to sort of start with a consultation. And if you say yes, we'll connect you with the client and you can sort of take it from there. All of our panel attorneys are covered by our malpractice insurance. We have the ability to connect you with other attorneys on the panel for mentorship support or guidance if that would be helpful to you in deciding whether to take on a referral. And so I think overall it's a process that works pretty well and that we would love to have you on board and get you involved with if you are not already connected to ALRP. There's more information on our website, and you can also contact Jake, who's on the call with us here, who's our pro bono panel manager, to get involved. And if you can't join as a panel attorney, or even if you can always support ALRP through a donation. All of the legal services that we provide in-house are completely free of cost to our clients. So your donations really help make that possible. And final thank you to all of the co-sponsors who helped publicize this series and who, are partners with us in the community. I'm sure a lot of the people on this training heard about us through them. So thank you to our co-sponsors. All right, that is the end of my little speech here. So I'm going to introduce Rachel and Becca, both from Oasis Legal Services. Rachel Kafele has 14 years of experience as an attorney working with low-income communities. After 3 years as a public defender in Miami, Florida, she transitioned to immigration law, where she co-managed the LGBT/HIV positive asylum program at the East Bay Sanctuary Covenant. Rachel co-founded Oasis in May 2017 and currently manages their legal and social services programs and represents clients in complex immigration cases. As an immigration attorney, she has represented over 800 asylum applicants before USCIS and EOIR. And Becca Holt is a staff attorney at Oasis, where she works predominantly on affirmative asylum claims and is beginning to take on SIJS cases as well. During law school, Becca interned at Oasis and never wanted to leave. She also was part of Berkeley Law's California Asylum Representation Clinic, and interned with La Raza Centro Leal's Defensive Immigration Team, completed 2 semesters with East Bay Community Law Center's Immigration Clinic, and volunteered to support humanitarian parole cases with the Berkeley Law Afghanistan Project. Becca's dedication to working with survivors of gender-based violence brought her to asylum law and guides her approach to this work. And we're really excited and grateful to have Rachel and Becca here with us today. And we're really grateful for their partnership with ALRP over the years and for everything Oasis does to support the clients we send your way. Just the work you do in our community in general. So I will hand it over to you and stop sharing my screen.
Okay, great. Just give me 1 second. I'll get our slides up here.
Yeah, and just want to say, the gratefulness and appreciation is definitely mutual. Thank you to ALRP for supporting so many folks living with HIV and also providing this wonderful training series as well. So thank you so much for joining us today. I'm Rachel Kafele. I use she, her pronouns. I'm the director of programs and advocacy at Oasis. I'm also one of the co-founders. And today we'll be talking about the basics of asylum law, specifically focusing on asylum claims for people living with HIV. And really the kind of what we want to tackle today is really how can we support our clients in finding safety in the United States. Becca, do you want to introduce yourself too?
Sure. Hi, everyone. My name is Becca Holt. Pronouns are she, her. And I'm a newer attorney, was admitted to the bar last year. And yeah, I love this work and I'm excited to be here with all of you.
Perfect. So just a little background on Oasis and what we do. So our largest program is our affirmative asylum program. We file around 200 affirmative asylum cases every year, and we really approach it like preventative health care. We want to support people with their immigration case before they enter deportation proceedings so that we can approach the case with time and support and kind of eliminate the fear of deportation that's our clients have. We then follow our clients on their immigration journey. So we help them apply for their lawful permanent residency, their green cards when they're eligible. We also work on family unification cases. So we help partners petition for partners who are not in the US or who are in the US without legal status. And then finally, we help our clients get citizenship. A huge part of our approach is our social services program. So we have social workers on staff who support clients in navigating resources such as mental health resources, connection to healthcare, HIV treatment, and job development, things like that. And we found that it's really important to provide this social service support so that clients are in a place where they can focus fully on their immigration case. And I see a question in the chat about, does Oasis provide affirmative asylum legal services to clients who are not LGBTQIA? We don't. So we help the LGBTQ community and also their family members. And that reminds me to say that if folks have questions, you're welcome to put them in the Q&A or the chat, and we will definitely get to them at some point during the presentation and definitely at the end. We can go to the next slide.
Yeah, and then I just wanted to add, Rachel, that, starting last month, we are also helping pro se asylum seekers in immigration court. So we'll talk in a little bit about the difference between affirmative and defensive cases, but those will be defensive cases. And we are planning to start offering full scope defensive asylum representation soon.
Yes, thank you. That's hugely important. So a little bit about our clients. We opened Oasis Legal Services in 2017, and we've directly represented over 2,700 folks from 68 different countries. And we have a 99% success rate helping our clients gain asylum. One of the really difficult things right now in asylum law is the huge backlog. So we have about 1,000 clients who have applied for asylum but still have not received their decision. So we have clients who have waited over 8 years for their asylum interview to happen and for them to get a decision in their case. Over 60% of our clients are non-English speakers. All of our staff who work with clients are bilingual, speaking Spanish and English. And then these are just some statistics about the clients we represented in 2023. 11% of our clients identify as trans or non-binary, and one in 5 are living with HIV.
Okay, great. So I'm going to go over the agenda for our portion of the training or the webinar today. I think on your slides there was a little formatting error, so they are all number 1, which is true in terms of importance, but in terms of the order, this is how we'll be tackling things today. Before I go through the agenda points, I do just want to highlight that something that's not on the agenda is, taking a trauma-informed approach and navigating trauma for yourself and your client. And those are incredibly essential parts of doing this work and are very much so trainings that we encourage before taking on asylum cases. Given that asylum cases are focused on really serious levels of harm that people have experienced or that they fear experiencing. I also wanted just to, mention that when we get to elements of an asylum claim. And when we get to the hypos at the end, we're going to focus on some, real life examples of our cases. And so, that will include some examples of facts that are disturbing, references that we won't read aloud, but that you'll see on the slides to, slurs and other comments that our clients receive, to help give examples of how to build these cases, as well as specific types of violence. So before we get to any slide that does include that kind of content, there'll be a warning on the slide before. If you, need to step away, that's totally fine. Please take care of yourselves. And please know that we, are bringing that content on these slides because it's essential to understanding the types of claims and cases. So to go over the agenda, we'll begin talking about jurisdiction, the different types of executive agencies and offices that have jurisdiction over the affirmative versus defensive cases. We'll then talk about the elements of asylum claims, and follow that up with the bars against receiving asylum. We'll discuss the evidence to include in cases, and we'll talk about how important credibility is, and how credibility is determined in these cases. At the end, we have a couple of hypos with some poll questions, and then we'll have time for Q&A as well with all of you.
Sorry. So did you have the first poll? Well, I think we wanted to get a sense of how, what folks' experiences are.
Yeah, I will launch that right now.
Awesome. So this is just to get a sense of how familiar we are with asylum, how many cases have we worked on, and we can give folks a minute or so to vote. Okay, I think we can show.
Or I can share the screen.
Great. So it looks like we're pretty evenly divided. That's great. We have some people who haven't worked on asylum cases before, and then people with lots and lots of experience. So awesome.
Okay. So we're going to start with the jurisdiction agenda item. So in asylum cases, as you've heard us reference already, there are affirmative asylum cases and there are defensive cases. And you can think of affirmative cases as the sword of seeking asylum in order to obtain legal status or to legalize your status, and defensive cases as the shield, raising an asylum claim as a defense when you're already in deportation proceedings. So in affirmative cases, these are cases where the client is not currently in deportation proceedings and has not been in deportation proceedings in the past. The client is seeking affirmative help from the United States in order to be safe from future deportation and to legalize their immigration status. Common examples of how an affirmative case might begin, a client may have entered without inspection, for instance, by, crossing on foot on the through the southern border and was never apprehended by immigration. Or the client might have entered with a visa, such as a tourist visa or a student visa, and overstayed their visa. And then by applying affirmatively for asylum, the client is essentially raising their hand and letting the government know of their presence or their continued presence in the US and asking for asylum. Affirmative cases are adjudicated by the United States Citizenship and Immigration Services, by the Asylum Office there. And you'll commonly hear us refer to USCIS, so United States Citizenship and Immigration Services. And the client is going to be interviewed by a non-adversarial or in a non-adversarial process that's conducted by a trained asylum officer. As I continually on my clients, that asylum officer is not a judge, is not a police officer, it is a staff member of the asylum office who's been trained in asylum laws to see if they meet the qualifications for asylum. And then defensive cases. So as I mentioned, these are going to be the shield against threatened deportation. the client would currently be in deportation proceedings as a result of having prior contact with immigration. The case is adversarial. The immigration judge, which you might hear referred to as an IJ, from the Executive Office for Immigration Review, known as EOIR, will be deciding the case. EOIR is part of the Department of Justice. In defensive cases, there will also be a lawyer from the Department of Homeland Security Offices of Chief Counsel, or OCC, who acts as the prosecutor. And that, Department of Homeland Security attorney will be doing cross-examination. So that's a much different and more adversarial part of the process in defensive cases versus asylum. Okay. In order to merit asylum, the client has to show that they meet the definition of a refugee. So the definition of a refugee comes historically from international law and is codified in the US in the Immigration and Naturalization Act, or the INA. The difference between an asylee and a refugee is that an asylee is already in the country that they are seeking to stay in. So they're in our context already here in the United States, and they're seeking status in the United States. Whereas a refugee, in terms of the legal sense, is someone who has fled their origin country, but has not yet gotten to the final country where they hope to seek safety. So for asylum cases, the first step is showing, though, that you meet this definition of a refugee. So a refugee is any person who is outside any country of their nationality, and who is unable or unwilling to return to, and is unable or unwilling to avail himself or herself of the protection of that country because of persecution or a well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. So on this slide, you'll see that the color coding here is showing the different elements that we're going to talk about on the next slide. So these are the elements that an asylee needs to show in order to, or an asylum seeker needs to show in order to grant asylum. So again, they are outside of their country of origin. The government of that country is unwilling or unable to protect the client. They have faced persecution or have a well-founded fear of persecution on account of, and then this is a list of the protected grounds, again, which are race, religion, nationality, membership in a particular social group, or political opinion. The definition also continues to include what a refugee is not, and we'll touch on that element and also other bars later in the training. Okay, so here are the elements from that definition broken down, and I see there's a typo on my part where it should be the fourth element instead of the third element repeated twice there. But just to repeat ourselves, so in an asylum claim, you need to show that the harm rises to a level of persecution. Persecution we'll talk about in more detail in the next few slides, but is an elevated level of harm. Then you need to show, second, that the persecution is on account of the third ground, a protected ground. On account of those connection words we talk about as a nexus, and a large part of the work you do in asylum claims is having to show what direct or indirect evidence there is to connect the persecution to the protected ground. Again, the protected grounds are race, religion, nationality, political opinion, or particular social group. And the fourth element is showing that the government was the persecutor, or if it was a non-government actor, such as a family member or anyone in the public, that the government is unwilling or unable to control that non-state actor's violence. Couple of other things that I want to highlight. So you can make a claim based on one or more enumerated ground. So we have these, 5 protected grounds here. The persecution could be a single incident of persecution could be related to intersecting grounds, or there could be 2, different types of incidents of persecution or examples of persecution that each have their own protected grounds. There's not a limitation on what you present, and in fact, you should present, all the arguments and all the incidents, and you don't have to limit yourself to one enumerated ground in presenting a case. The ground can be actual or it can be imputed. So you could seek asylum, excuse me, you could seek asylum because someone has persecuted you because they think you hold up certain political opinion, even if you might not actually hold that opinion. Or for our clients, for instance, because someone might persecute you because they think you are gay, but you might not be in actuality. The unwillingness or the inability of the government to protect can be established in several ways. So, actual failure to protect, the client actually went and sought the protection of the police and the police did not act. It can be shown through futility or danger of reporting, failure to protect similarly situated people. It can be shown through the laws on the books of the government. But something else to keep in mind is the enforcement of law. So even if a country has good laws on the books that might protect clients from violence or discrimination based on one of these grounds, if there's impunity or that the law is not able to be enforced or isn't enforced, that can also be used to show inability or unwillingness. Okay. At the bottom here, we have the note that there are these, 4 factors plus the discretion of the adjudicator. Discretion is important in these cases, and asylum is a discretionary grant, meaning that even if someone meets these elements and can show that they meet the definition of a refugee, the adjudicator still has discretion about whether or not to grant asylum. In assessing or in using their discretion, the adjudicator needs to consider both favorable and unfavorable factors. It's an abuse of discretion if they don't give any weight to the favorable factors, for instance. Some of the factors that come into play are the applicant's health, family ties, separation from a spouse. Those can be things that might be favorable factors. Immigration fraud, uncontested evidence of immigration fraud is sufficient to support a discretionary denial. But you might be able to mitigate, for instance, with showing that someone used false documents to enter the country because of dangerous circumstances on their journey or from their origin country that, obviously push them to flee, kind of using any means possible to enter the country. Criminal record, as well as drug or substance use, can also be negative discretionary factors, but rehabilitation in both cases will be favorable factors. Okay. All right, so when it comes to showing the persecution element, these cases have both a past and a future or a forward looking perspective. So persecution can either have occurred in the past or you can have a claim where persecution or harm is something that they fear and the client fears in the future. So it can be granted on either basis, and you should present both if you should present both in the case of there being both past and future persecution. Past persecution, so things happening to the client in their origin country, also gives rise to a legal presumption of future persecution, which kind of makes sense, right? I'm afraid of something happening to me in the future because of what happened to me in the past. However, the government can rebut that presumption by showing that it's reasonable for the client to relocate inside of their origin country and be safe, or showing that there are changed circumstances in the country that would make the client safe from future persecution. And again, you can have a case that is entirely forward-looking, entirely about a well-founded fear of future persecution. and that has a subjective and an objective component. So the subjective component of fear, the fear must be genuine. So that's about the client's state of mind. The objective component, is a reasonable person standard. A reasonable person would experience or fear persecution. And, case law suggests that is, you could roughly use a 10% chance of persecution that will substantiate a well-founded fear. Okay, I want to talk about what harm rises to the level of persecution. Physical harm consistently is sufficient, and there is a case law site that also shows that attempted sexual violence will rise to the level of persecution. Threats may rise to the level of persecution if severe enough and if imminent. Poverty, harassment, and or discrimination are generally not enough. However, there is some case law that shows that substantial economic deprivation can be persecution. So that's going to be more extreme cases where, for instance, there is a substantial economic deprivation that constitutes as a threat to life or freedom. And that's looking like more severe circumstances that are past mere economic disadvantage or generalized economic disadvantage. It's also important to keep in mind if the persecution or the harm happened when the client was a child, because the perspective of a child will be taken into account, and that might raise something to the level of persecution, because a child might fear or might experience that harm more acutely than perhaps an adult would. And we can also use the cumulative effect. So perhaps one instance of bullying in school might not be enough, but years of continued bullying and harassment can be shown cumulatively to get to a level of persecution.
Okay, thank you. So now we're going to go through the protected grounds. The first three that we're going to talk about are race, religion, and nationality. And there's actually can be some overlap between these three protected grounds. So as Becca said, you can assert more than one protected ground in a case, and it's important to do that because you want to preserve your client's right on appeal. So for race, that can be it's pretty broadly defined. It could be an indigenous group such as Mayan folks from Guatemala. It could be an ethnicity. It could be the color of one's skin. Religion can overlap with political opinion, for example, with people who practice Falun Gong or people from Tibet, or it could overlap with ethnicity, for example, Jewish people or Tibetans. And then when you are asserting religion as a protected ground, it could be that your client was persecuted for practicing the wrong religion. Maybe they were too religious or not religious enough, or they were challenging gender roles within a religion. They were atheist, agnostic, or maybe your client was targeted because of their parents' religion. So you want to think broadly about all of these. And then nationality doesn't just include citizenship. It could be an ethnicity or a linguistic group, and a lot of times nationality will overlap with race. And then political opinion can be a lot broader than one may think. So it's not that you are part of a political party or that you're part of the government or affiliated with government opposition or a government regime. It can also be a strongly held belief. So feminist beliefs or beliefs about the use of violence, for example, could be considered a political opinion. And then this is a good time to kind of provide some examples about what Becca was talking about in terms of actual or imputed. So you can actually hold the political belief. So for example, you believe in equal rights for people living with HIV or equal rights for queer and trans folks, and then you campaigned and experienced persecution because of that. or it can be imputed so that the persecutor believes you to hold the opinion regardless of whether you do or not. So this would probably be shown in a situation like this, where the soldiers accuse someone of participating in the protest just because they were friends with the people that were involved, or sometimes it's because the person is walking down the street at the wrong time and the police or government see them physically close to the protest and then target them because they believe they're a protester. Just to go back, sorry, one more thing on political opinion. So it's important to establish, as in all the protected grounds, what the opinion is and how the persecutor knew your client to have that opinion, or how the persecutor demonstrated that they imputed the opinion to the client. So you're first going to have to formulate with your client what that political opinion is. That's kind of the first important step. All right, so now on to particular social group, which is kind of the messiest protected ground, or kind of the all-encompassing one. So the BIA, the Bureau of Immigration Appeals, which is if you lose your case in immigration court, you can appeal to the Bureau of Immigration Appeals. So they have a 3-factor test about what makes a particular social group cognizable. So first, the group has to include people who share an immutable or fundamental characteristic. So members of the group should not have to change that characteristic, or they can't change that characteristic because it's fundamental to their individual identities or consciences. The second one is social distinction. The group has to be socially distinct. So it needs to be understood to exist as a recognized component of the society in question. So this isn't an on-site test. It's not like about ocular visibility. It's kind of about social visibility. And we'll talk in later slides about how you kind of show that, but you get newspaper articles that refer to this group as a group, and that would be a strong argument that the group is seen as a group by society. Or perhaps there's laws that are passed by the government that target this particular group. That could be a sign that they are perceived as a group by society and treated differently. And then finally, the particularity prong. So a particular social group must be defined by characteristics that provide a clear benchmark for determining who falls within the group. So it's not necessarily referring to the size of the group, and the case law says it doesn't need to be interpreted to require doesn't have to all be the same in all respects, but it's kind of a line drawing exercise. You need to be able to say who is in the group and who is not in the group. Okay, so these are some common particular social groups that have been recognized in the case law. So LGBTQ+ identities have been recognized in case law, and this is kind of an example of how you formulate them. So Mexican lesbian women or transgender men from Iran. So you want to state the sexual orientation and or gender identity, and then say the country. Child abuse and domestic violence are also particular social groups. What's important, especially when articulating a particular social group around child abuse or domestic violence, is that it can't be circular. So you can't say, women who are the victims of domestic violence. So you can't use the harm to define the social group. So instead, courts have recognized social groups that are articulated, children viewed as property, or women viewed as property by virtue of their position within a domestic relationship. A lot of domestic violence PSGs are articulated by married women in X country who are unable to leave their relationship. Family can also be a particular social group. The case law has narrowed this, however. So in LEA, the BIA held that mere membership in a family or familiar relationship is insufficient to establish nexus to a protected ground. So just being in a family is not enough. You have to show that the persecutor was motivated to harm that person by their membership in that family. And then in MRMS, again, this asylum case was not granted because they did not find that familial ties were one central reason for, in this case, it was a gang, for the gang's persecution of the asylum seekers. And then there are gang-related PSGs. There's not great case law about this, but these are some PSGs that people use when the persecutor is part of a gang or other criminal group. And then it's just important to remember that you always need to demonstrate actual or imputed membership in the group. So when you're putting forth your client's asylum claim, you're going to have to put forth evidence that they are LGBTQ or they are living with HIV, or that people believe that they were part of that group. We can go to the next slide. So then this is some helpful case law for folks who are representing asylum seekers who are living with HIV. So the first kind of time it appeared in case law or in kind of among INS used to be the old immigration agency. So they put out a memo in 1996 that said a person with AIDS can qualify for asylum, that can be the particular social group. And from there, the case law has recognized that. So one way to formulate the PSG would be people from X country who are HIV positive, or people from X country who have AIDS. And then also related is that, and there's a lot of belief in many parts of the world that anyone who is living with HIV is also LGBTQ. So there's the issue or the element of, if someone is living with HIV, people could also think that they are LGBTQ and persecute them because of that. So in this case, it was HIV positive people who are imputed to be LGBTQ based on their HIV status. All right, so we've talked about persecution, we've talked about protected grounds. Now we're on nexus. So we need to connect the persecution to the protected ground. We need to form that nexus. So you're not always going to get direct evidence of nexus, but you can also use indirect evidence as well, and we'll talk about that on the next slide. What's important to know is that the protected ground does not need to be the only reason for the harm. So case law says that instead, the protected ground needs to serve as one central reason. So mixed motives of the persecutor are allowed. You can think of it as a but-for causation. So the protected ground needs to be an essential reason for the harm. The harm can't be incidental or subordinate to another reason. And this is why generalized violence or random crime is not going to be enough to show that nexus. So if your client, you're arguing that they're part of a protected group, but someone just comes up and randomly robs them in their country of origin and don't say anything about why they were robbed, that would be hard to show the nexus, because it seems like you're not going to have that protected ground being one central reason of why they were robbed.
And then, as we mentioned earlier, when we talk about nexus, we're going to talk about that like direct and indirect evidence. So there's going to be some, content warning material on the next slide. So I just wanted to give that now and just give a second before I go to the next slide. Okay, I'm going to continue onward to talk about Rachel's going to talk about the direct and indirect evidence.
Okay, thank you. All right, so direct evidence is can be a little harder because most of the time someone who's harming someone else they're not necessarily saying, I am harming you because of this reason, but sometimes you do have direct evidence. So this is where you really need to work with your client to talk about what happened to them and ask questions that kind of get at this information. So we have had clients who have been sterilized because they are living with HIV. And the doctor has said that to them. And so that would be direct evidence. And then we've also had clients who have been directly threatened or harmed because they are living with HIV, and the persecutor has very clearly said that. Indirect evidence is really important as well. And so these are some examples of how you can show indirectly that your client was harmed because of their protected status. So for example, if someone before has insulted a client, made comments about their race or their religion, and then the next day physically harms them and doesn't necessarily say anything to them on the day they're physically harmed, you can point back to those comments from an earlier day and try to make the connection that way. Perhaps a parent finds someone's medical records showing that they're HIV positive, and then they think that they are gay and kick them out of the house. That's the second example. And then a kind of political opinion related to rights for people living with HIV. If someone is participating in a protest for LGBTQ or rights for people living with HIV, and then they're experience persecution because of that. Maybe they're imputed to be gay or they're imputed to be living with HIV. All right, so now we're on the fourth element, which is showing that the government is going to fail to protect your client. So there's two ways of doing that, like Becca explained earlier. First, the persecutor could be a government official. So you need to show that it truly was a government official. So for example, if your client was harmed by the police, you're going to have to show how your client knows that it was the police. So were they wearing a uniform? What did they say that made your client believe they were the police officer or a government authority? So you're going to have to kind of put forward evidence that it really truly was a government official. If you're able to do that, then internal relocation is presumed unreasonable, because if it's the government going after your client, then nowhere in the country is going to be safe for them. So for private actors who the government is unable or unwilling to control, you don't have to show that you reported the harm to officials. But if your client hasn't reported the harm, you're going to have to show supporting evidence that the government is unwilling or unable to protect. So that's through your client's testimony. For example, maybe friends of theirs tried to report abuse and the police did nothing. Perhaps they saw the police persecuting people from their group. You also are going to want to submit country conditions, and we'll talk about country conditions in a little bit, that show kind of the generalized conditions of the country, how well or how well not the government protects people in that country. And then the note about potentially undermining evidence, and we'll talk about this when we talk about country conditions too. But sometimes in an article where they're talking about how the government doesn't protect their citizens or protect people in this protected group, 2 paragraphs later, they say, but the government is working to change this and to pass laws that will protect people in the future. So and this kind of comes up in the case law where the court says, the country conditions submitted show that conditions were improving, that the government was protecting people more, and then it undermines your argument that they are failing to protect people in your client's situation. And then these, if you are representing a client who is living with HIV and you're putting forth an asylum claim based on that, these can be some helpful cases. Matter of Toboso Alfonso is kind of the seminal case that established sexual orientation as membership in a particular social group. And from that, there was then this INS memo that said in certain circumstances, persons with HIV or AIDS may constitute a particular social group under refugee law. And then the first time that memo was mentioned, and the Ninth Circuit is in this Caruni v. Gonzalez case that confirmed that HIV status is recognized if it's as a particular social group. And then Boer Sedano v. Gonzalez is also a helpful case. It contains good language about how the applicant's HIV status made internal relocation within Mexico impossible.
Okay, great. So this is just a recap of what we've gone over so far about establishing eligibility for asylum before we move on to the bars to applying for asylum. So again, you can establish eligibility for asylum with a case about past persecution, in which you'll get that rebuttable presumption of a well-founded fear of future persecution. The government has the burden to rebut by preponderance of evidence by showing either changed circumstances that make it safe for your client in their origin country, or that that there is reasonable internal relocation, meaning maybe your client was not safe in their particular hometown, but could be safe in another part of the country. Or you could have a case that is entirely built on just a well-founded fear of future persecution, where the client has not experienced past persecution. That can be really common for our clients, for instance, who came to the US when they were, super young. We want to talk about how you can overcome the government's rebuttal when you're working with past persecution. So if you have a case with past persecution, the government perhaps has met its burden to rebut by either showing changed circumstances or reasonable internal relocation. You can overcome that rebuttal still. There are two ways to do that. So one is through humanitarian asylum, where you point to other serious harm that the client would experience if they were forced to return. Past persecution plus other serious harm upon return. There doesn't need to be a nexus for that other serious harm. So you could point to a medical condition that the client could not get treatment for in home country that doesn't have any relation to the asylum claim or to a nexus, and that could be a way to show other serious harm, harm from criminals or gangs, again, that doesn't have a nexus, maybe because the motive is just, criminal motivations. And then second, the other way to kind of overcome the government's successful rebuttal would be humanitarian asylum by showing severe past harm. So this is basically an argument from this case matter of Chen that shows argues that the client's past persecution was so severe and atrocious that for humanitarian reasons, they should not be forced to return to that country. And, there's case law about what types of persecution would be this severe and atrocious harm. Okay, so now we're gonna talk about the bars to grant of asylum. So the first hurdle in the case, right, is showing that you meet the elements. The second hurdle in the case is showing that, showing that your client isn't subject to any of these bars. Okay, so bars to applying for asylum. And again, that star there are other forms of relief that we aren't talking about today that are closely related to these cases, which are withholding of removal or relief from the Convention Against Torture, or CAT. So these are bars to asylum that don't impact withholding or CAT relief. And they included denial of a previous asylum application, something that's called the safe third country. So under the INA, your client may not apply for asylum if that person may be removed under a safe third country agreement to a country where the client would have access to full and fair procedure for seeking asylum. So the US and Canada maintain a long-standing safe third country agreement in which non-Canadian nationals arriving at US ports of entry from Canada may not seek asylum, and related protections in the United States. Notably, this restriction was expanded to people who cross between ports of entry under the Biden administration. And we will be talking about other updates related to some Biden administration bans as well. Exceptions to these safe third country agreements, it's hard for me to say, include where the client's family members in the United States have received asylum, or where, as a matter of public interest, an applicant should be allowed to pursue asylum in the United States despite the safe third country agreement. There were some Trump administration safe third country agreements with Guatemala, Honduras, and El Salvador, but it is important to know that only the Guatemalan agreement was implemented, and in 2021, the Biden administration suspended those 3 agreements. And again, we'll talk about updates in the Biden administration later. And then a really important rule, sometimes called a bar, is the 1-year filing deadline. Asylum seekers are supposed to seek asylum within their first year of their last arrival to the United States. And that is a big hurdle to overcome in cases, but there are exceptions. And I would say at least half of our clients are applying after the 1-year filing deadline. So after 1 year since their last entry, using one or both of these exceptions. So one exception is called extraordinary circumstances plus reasonable time. The other exception is changed circumstances, again, plus reasonable time. Reasonable time does not have a specific definition, but there is case law suggesting that, you can think of it as a 6-month time frame, but applying sooner is always better, because that's not a bright line rule. An example of extraordinary circumstances that is really common in our cases would be mental disability. For instance, a trauma-related diagnosis like PTSD, that can be an extraordinary circumstance that has prevented someone from applying for asylum sooner. Changed circumstance, an example in our casework might be a recent HIV diagnosis. So that's a changed circumstance in that person's life that now would make it more dangerous or would give them a well-founded fear of future persecution. So that is another explanation for why they didn't apply for asylum sooner. Okay.
I just wanted to do a time check because we're at 1 o'clock, so we have 15 minutes left.
Okay. So so we'll go quickly then through these bars. And because I think Rachel has really important information to go over about some of the updates with Biden era asylum bans. Firm resettlement, meaning an offer of permanent legal status in another country, is a bar to receiving asylum. People who have persecuted other people, so again, that's going to be related to the grounds for asylum in order to be persecution, are barred from receiving asylum. There are some types of crimes that are bars from receiving asylum, but not all types. So there's analysis that should be done for any clients who have a criminal record. But conviction of particularly serious crimes or a serious non-political crime committed outside of the United States. Engaging in terrorist activity, which is a really, really broad definition, and includes material support, which can be even de minimis support. So food, shelter, extortion payments, and also applies to people who provided that support under duress. And then threat to national security is another bar for asylum. Okay, I'm gonna hand it over to you, Rachel, then to talk about the asylum bans.
Yes, so in the past 2 years, the Biden administration has, through kind of rulemaking, enacted 2 more asylum bans. So this is the first of the asylum bans. It's called Circumvention of Lawful Pathways. That's the official name. We kind of call it Biden's first asylum ban. So it began on 11/59 on May 11th, 2023. And right now it covers any entry into the US at the southern border for a period of 24 months, but there's currently an open notice and comment period to see, the US is basically seeking to make this rule permanent. So the rule applies to all non-Mexican adults and families seeking asylum at the southern border and all maritime arrivals in the same region. And basically what the rule does is it creates a presumption that the applicant is ineligible for asylum unless they or their spouse or a child with whom they are traveling meets an exception. So these are the exceptions. So either the person is an unaccompanied child, so they are a child under 18 who is not traveling with a parent, or they are entering the US with an approved parole application. So those would be people from, I forgot to put on Ukraine, but Ukraine, Cuba, Haiti, Venezuela, or Nicaragua. These are programs that the US has rolled out for people who are still in their countries of origin in order to come to the US. Under the circumvention of lawful pathways, you can also apply for something called a CBP-1 appointment. So there is an application, a cell phone application that the US government has created for people to use while in Mexico. You have to be in Mexico to use this. You then sign up for an appointment, and then you get an appointment like 8 months later to appear at the border and state your claim for asylum to see if you will be let in. So the cell phone application is hugely problematic. It's only in 3 languages. The wait times are really huge. It's pretty awful, but that is one way that you can not be subject to this rule. Another way is if you applied for asylum in a transit country and received a final decision denying your claim. So if you are from El Salvador, you applied for asylum in Guatemala when you were going through Guatemala and you were denied. We can go to the next slide. So that was the first Biden asylum ban. This is the second Biden asylum ban. Its official name is Securing the Border, and this one wasn't even done through a rule. It was done through an executive order, and it's been in effect since June 5th, 2024. And it's based on how many encounters that Border Patrol and DHS have with people who are entering between ports of entry per day. So once an average of more than 2,500 people are encountered by DHS between ports of entry over a 7-day period, this ban goes into effect. So since June 5th, this ban has been in effect because we're really never going to get to a number below 1,500 for a day for 28 consecutive days. So when this ban is in place, it's basically very similar to the circumvention of lawful pathways rule. There's only a couple of exceptions: people who are granted parole, people who are presenting themselves pursuant to this CBP-1 appointment, or unaccompanied children. The big difference is that under this second asylum ban, people from Mexico are included. So this ban is basically trapping people in their country of origin and making them wait for an appointment that they make through a really problematic cell phone app. We can go to the next slide. Under both rules, we talked about the exceptions. So you can also, like I said earlier, if you don't qualify for one of these exceptions, then you are presumed ineligible for asylum. You can rebut that presumption by showing exceptionally compelling circumstances. So the 3 kind of buckets they articulated under these rules are acute medical emergencies, imminent and extreme threat to life or safety, or having previously experienced a severe form of trafficking in person. So because these rules are pretty new, we don't have a lot of adjudications kind of letting us know what DHS or EOIR are thinking are acute medical emergencies, but things that we have argued that, again, we haven't received any decisions are someone who was passing through Mexico, ran out of their HIV medication, started to feel sick, because of the lack of HIV medication, so therefore couldn't wait in Mexico, didn't have access to HIV medication, and then had to enter the United States without waiting for their CBP1 appointment. Imminent extreme threat to life or safety, threats, death threats, kind of whatever, I would argue, whatever rises to the level of persecution in an asylum case should be an imminent and extreme threat to life or safety. So being kidnapped, being sexually abused, being physically abused. And then having previously experienced a severe form of trafficking in persons, there has been clarification that that means the person could be trafficked in their country of origin. They could have been trafficked on their way to the United States. So they're basically forced to do work under the threat of violence. And so kind of using the definitions that are already in immigration law about what is a severe form of trafficking in persons, that's how you would make that argument. Okay, we have about, I don't know, 5 minutes left. We're just really quickly going to go through kind of what evidence that you use to prove an asylum case. So the law changed in 2005 with the Real ID Act, but it's important to know that the law did not change, that an asylum case can solely be based on credible testimony. So many of our cases at Oasis it's our client's testimony that gets them asylum. So they are talking about their own story in a credible way, a consistent way, and that is enough. And that is why it's really important to always submit a declaration. So this is your client's first person narrative of what happened to them in their country of origin and why they're afraid to return. So you always want to submit a declaration. And then if the Real ID Act did say that if there's corroborating evidence, such as a witness affidavit, someone who saw the persecution happen to you, or there's medical records from your hospitalization after the persecution, it's your responsibility as the asylum seeker to get that if that evidence exists. And if you don't get the evidence, you then need to give a reasonable explanation for why you can't get it. We've talked about country conditions throughout the presentation. So country conditions help show that that your client's fear is objective, and it also corroborates their past experiences. So country conditions can be news reports or articles from the client's country of origin, or perhaps done in the US or in Europe, that show what it's like to be in that country for a person in your client's situation. So at Oasis, we have collected a lot of country conditions for LGBTQ asylum cases for many different countries. And our last slide will have a link to how you can request them. So we're happy to share country conditions with folks. And then this is less so in front of the asylum office in affirmative cases, but in immigration court, it's usually very important to have an expert witness testify, and the expert witness can establish certain elements of a claim. So, to help your client get over the 1-year filing deadline by saying that they have a diagnosis of some trauma-related disorder, or it's a country condition expert that is talking about country conditions in that particular country, or the existence of a specific ethnic group, etc. So it's important to really fully prepare your case because it is your burden to show that your client qualifies for asylum. And then finally, credibility. So this is important because, like I said, an asylum case can be based just solely on credible testimony. But this is also where a lot of asylum cases fail, and a lot of people are not granted asylum because of negative credibility determinations. So credibility under the case law is based on a totality of the circumstances. It includes all relevant factors, which the court goes on to say, which is consistency between your client's testimony and all the evidence they submit, the demeanor, candor, or responsiveness of your client or another witness, and also the inherent plausibility of your client's account or another witness's account. And what the Real ID Act changed is that before, it didn't matter. It mattered whether the inconsistency went to a material aspect of the claim. So if the inconsistency went to something that wasn't really important in the case, it wouldn't go to credibility. But under Real ID, that changed. So now it does not matter whether the inconsistency, inaccuracy, or falsehood goes to the heart of the applicant's claim. And that's why credibility has become so important.
So in your slides, we have this little cheat sheet that, goes over the eligibility elements, the bars, and discretion to help you assess not just the hypos, but any case. Given the time, do we want to do just the first typo, Rachel? Or do you want to go to Q&A?
There don't, sorry, I'm losing my voice. I don't see any unanswered questions. So I think we could maybe do, unless people have been holding their questions, in which case, please put them in the chat or the Q&A and we can answer them.
Okay.
So we could, yeah, we have 2 minutes left. So we could quickly do the first typo.
Okay, great. And again, just a content warning for the hypos, because they do go over facts that are upsetting.
Okay, so our first hypo will give you 1 minute to read it, and then we're going to put up the poll question. Okay, here is the poll. So what grounds for asylum might you explore with Remy? And then we're going to please select anything that that applies. Okay, and I think we can publish the responses. Okay, so it seems like most people said nationality, yes. Honestly, I think if I was Remy's lawyer, I would put everything in. I would do all the 5 protected grounds. Because as we talked about, people from Tibet it can be a race, it can be a religion, it can be a nationality, it can be a political opinion. And then also you can make arguments based on country conditions also that Remy is a member of a particular social group. So perhaps women in China or Tibet are treated differently, and therefore they would be a particular social group. And so just quickly as an exercise, what, if you want to put in the chat, what questions would you ask Remy in order to get evidence of nexus? So if we look at the hypo, we can see that maybe there's harm because she was detained and held in custody for 1 week, and she was interrogated, and we could argue tortured. She felt painful contractions, and then she was spit on, but we don't have any words said by any of the persecutors. So what are some questions that you would maybe want to ask Remy? So you have someone who says, what country were you born in? And also there's another question, kind of who are the people persecuting her? Yeah, why did she attend the Dalai Lama's celebration? Why is his birthday important to you? Maybe that's getting at political opinion or religion. Yeah, what did the police say to you when you were in custody? I think that's the question that, we ask the most during declarations is you elicit what the client went through, the harm they experienced, and then you always follow that up with, and then what did this person say to you? Because that's really how you're going to show nexus.
I think just because we are at time, I'll invite people to consider the hypo on the next slide themselves. There are some good questions in relation to particular social group and what rose to the level of persecution, how the client might get over the 1-year filing deadline to consider. And I will bring us to our final slide here. and just say, thank you, happy to answer any other questions for those who have them. And Rachel, if you want to highlight these resources, that would be great.
Yeah, so it was a lot of information jam-packed into an hour and 15 minutes. So please email us any questions. We're happy to answer and support. Like I said, we do have country conditions for a wide variety of countries for LGBT asylum cases. We also have other resources like a guide to help people prepare for their asylum interview or sample briefs. So you can request that on that case assistance link. Also, if you ever want to look up more about us or refer people to us, that's our website as well.
Okay. Thank you all. Have a happy
thank you.
Halloween.
Yes.
Thank you both so much for presenting with us. I thought this was really, really useful and really clear information. Just a reminder to everyone as you leave, you'll be sent to the evaluation form. Please make sure to fill that out, and we'll get certificates of attendance out to you within a week or so. It may be a few days just because there's always a lot going on. But appreciate everyone showing up today. And of course, thank you to our presenters, and have a great afternoon.
Thank you.